The Senate is voting today on a measure that would make abortion legal in the United States. The bill is not expected to reach the 60-vote threshold, but Senate Democrats say the point is to tie each lawmaker to their vote. This, of course, comes after the leak of the draft majority opinion indicating the Supreme Court is poised to overturn Roe v. Wade.
And joining us with more on this is senior advisor at Banyan Global, Beattie Frelinghuysen. She's also a former law clerk for late Supreme Court Justice Ruth Bader Ginsburg. Lisa, welcome. It's great to have you with us. So obviously, we're talking about a leaked version of a potential Supreme Court opinion. But what are some of the legal weaknesses you've identified in Justice Alito's opinion as it's written in this leaked version?
Sure. Tanya, thank you for having me. As you know, Roe was based on a right to privacy that was not in the Constitution, but emanated from the Bill of Rights. And Casey, which affirmed Roe, was found a 14th Amendment liberty right protected a woman's right to choose, and said that states cannot impose restrictions that enforced an undue burden on women's access to those rights. This case in Dobbs, Alito, who's drafted this leaked opinion, overrules those two cases with a historical analysis. Basically, he says, look, if there is no right to an abortion in the Constitution or in the 14th Amendment, we need to look back at our nation's history and see if that right is deeply rooted in our nation's history and traditions. And really no surprise there, he finds that at the time of the Constitution or thereafter, when the 14th Amendment was drafted, there were no laws that were protecting a woman's right to choose. So he disregards really the last 50 years of women's rights cases, of our evolved understanding of what equality and liberty means today, what privacy means today, what those constitutional foundational principles have the court has given meaning to as our society becomes more enlightened, more nuanced about those concepts. So it's a somewhat of a circular argument, finding that there's no historical precedent for this right way back when women really were not part of the Constitution. It doesn't, that rationale is not one that makes a lot of sense.
Lisa, as you know, opinions aren't only scrutinized for what's in them, they're also examined for what's not in them. Are there any glaring absences that you've noticed in this leaked opinion?
Well, the biggest absence, I would say, is the lack of recognition around women's equality, around women themselves. I mean, there's very little mention of women and what this means for women. And there's almost no references to most of the big women's rights cases, the gender equality cases that the court has heard since the 1970s. I was surprised to see that lack of reference, to be honest.
And Lisa, sorry, to your point, when you see that that's not in there, you can read a little further into those arguments, can't you? And what else does it suggest could be at risk?
There's a number of cases, a number of rights at risk, Tanya. Basically every case that was based on the 14th Amendment substantive due process clause, liberty and privacy are really now at risk. And those would include the right to contraception, the right to interracial marriage, the right to gay marriage, the right to intimate relations. Those are all based on the same line of constitutional analysis. And while Alito does try to distinguish this case from those, saying that this case involves fetal life, or as he terms it, the life of an unborn human being, they're based on the exact same rationale. So I think most legal scholars would say those other big landmark cases are currently at risk now.
Right. And Lisa, really quickly before we let you go, because we're almost out of time, what would your mentor, Justice Ginsburg, have thought about this opinion?
Well, she would have been devastated. I mean, she cared deeply about gender equality. I think she felt strongly that this right to an abortion is well grounded in the Equal Protection Clause as well as the 14th Amendment Liberty Clause. She saw it as essential to gender equality in our country.
Lisa Frelinghuysen, thank you so much for your insight. We appreciate it.
My pleasure.